Welcome to a special edition of our commercial bulletin brought to you in association with LexisNexis. This month we're taking a look at the big legal changes expected in 2017. For more information on any of these stories, don't forget to download our News In document using the link shown on your screen now. Brexit dominated the legal news in 2016, and this is set to continue throughout 2017. In the next few weeks, the Supreme Court decision will determine whether the government can trigger Article 50 without Parliament's approval. The abolition of corporate directors under the Small Business Enterprise and Employment Act had been scheduled for implementation in October 2016. Following its postponement, we expect to see the implementation of this provision in the early part of this year. The SBEE includes a provision to nullify contract clauses that prohibit the assignment of receivables in most business-to-supplier contracts. This provision is expected to be implemented in April. We expect to see parts of the Enterprise Act 2016 implemented in the spring of this year. One of the provisions is the creation of a Small Business Commissioner to support businesses that are having challenges with larger businesses, particularly on payment issues. Other changes being implemented by the Enterprise Act include an implied term into all insurance contracts to obligate the insurer to pay claims within a reasonable time, and increased rights of shop workers to opt out of working additional hours on Sundays. The government announced in late 2016 that provisions under the SBEE requiring large companies to report on their payment practices will be implemented in April. This is likely to include stating the percentage of payments made within 30 days, 30 to 60 days, and 60 plus days. We anticipate that 4MLD will be implemented in June 2017 and will make numerous changes to existing anti-money laundering laws, particularly the requirement to have beneficial ownership of companies reported in real time rather than annually. The UK government has issued plans stating that from spring, company directors can each be fined up to £500,000 by the ICO if their firm is found to be responsible for nuisance calls or spam text messages that breach privacy laws. The Pimlico Plumbers v Smith case is listed for hearing in a Court of Appeal this month. This is to determine whether the plumber was an employee, worker or self-employed. The Employment Appeal Tribunal had previously held that the plumber was a worker rather than being an employee or self-employed. This case and other similar cases such as Aslan v Uber help to provide guidance on employment status. Large private and voluntary sector employers, that's employers with 250 plus staff, must carry out a data snapshot of gender pay differences on the 5th of April and each anniversary thereafter. Employers have 1 year from this date to publish the data. The Trade Union Act of 2016 is expected to be implemented in the spring. The changes include increased ballot thresholds, strike mandates limited to 6 months, doubling of the notice requirements of strikes to 14 days, and more clarity on the words used in the ballot paper. From April, the government's new apprenticeship levy will see large employers paying 0.5% of their annual wage bill towards the cost of apprenticeship training. Subject to some exceptions, it is possible to recover £1.10 for every £1 paid by the employer for training and assessments of apprentices. In late 2016, an employment tribunal ruled that lower paid women working in Asda stores can compare themselves to higher paid men who work in Asda's distribution centres. An appeal of the Employment Tribunal's refusal to strike out the claim is to be heard by the EAT on the 26th of April. The Court of Appeal heard the lead Commission holiday pay case in 2016 and determined that Locke was entitled to average commission during holiday periods. An appeal to the Supreme Court has been lodged that is expected to be listed in the middle of this year. Meanwhile, the Fulton v Bear Scotland is the lead case concerning whether employers must take into account non-guaranteed overtime payments when calculating basic holiday pay. We expect to hear the outcome of this case early this year. The first application for an opt-out collective proceedings order, a CPO, was heard in December, and we hope to have a decision early this year. This follows action taken by the Office of Fair Trading against Pride Mobility Products and some of its retailers for breaches of competition laws in 2014. The CPO will allow all customers of Pride to claim compensation unless they have opted out. It's understood there may be 34,000 customers, each claiming £200 compensation. The final report of the European Commission's e-commerce report is expected in the first quarter of this year. The report will elaborate on the Commission's concerns that the digital market is not working effectively. The Commission has already stated that it is particularly concerned about geo-blocking and other forms of unilateral discrimination based on the customer's nationality. The European Commission has already produced a draft regulation that is expected to be implemented in June or July. Thank you for tuning into this month's Commercial Bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in February with more of the month's key legal updates.